Hello, Mrs. Jones. Thank you for contacting me. I have read your concerns and would like to take the time to give you the legal advice that you have inquired about. Yes, I understand your fears, and please don't be offended when I say that those fears are legitimate. Legally, your employee has not broken any laws or regulations. According to the law, it could be considered discrimination in you asking her to resign. As you likely know, the FMLA provides the employee with certain leave rights. Unlike the PDA or the ADA, the FMLA applies in this situation to both the pre and post birth leave. The FMLA requires covered employers to grant leave to employees for reasons including one, a serious health condition that makes the employee unable to perform the function of the position of such employee, in your case, the preeclampsia, and the birth of a son or daughter of the employee and in order to care for the or daughter. The PDA prohibits discrimination against pregnant women. This act applies only to the determination of the leave issue while the employee is on medical leave. The PDA requires an employer to treat the pregnant employee the same as if she were not pregnant. In the case of a request for additional leave beyond that permitted under the FMLA, an employer must treat the pregnant employee the same as it would any other employee with a medical condition that prevented the employee from working for a set period of time, such as if Mr. Tom had a brain tumor all of a sudden and he needed to be out emergency. Maybe he came back, maybe he didn't. Who's to say? His is as serious as her preeclampsia and her being pregnant. It's not a moral issue. I understand that it's a role model for girls, but she has been hired. This hasn't been in her contract. And legally, she can seek litigation. If your company has a policy providing for additional leave, that leave must be offered to the pregnant employee under the same circumstances as it will be offered to any other employee with a health condition requiring leave. Depending on the types of complications caused by the pregnancy and the extent of the medical restrictions, an employee may also be disabled under the ADA. She will qualify as disabled if the unusual physical impairment caused by her pregnancy affects a major life activity, and that major life activity is substantially limited by the impairment. Prior to the passage of the ADA Amendment Act of 2008, there were court decisions ruling both ways on the issue of whether pregnancy complications constituted a disability. After evaluating the measures you have taken and are willing to take, it is my suggestion that first you try to see if your employee is willing to come in and discuss the matter on her own free will. If she is, it is in your best interest to engage in proper communication with her and grant her medical leave. She has a huge lawsuit waiting for you should you continue with your plans to terminate her. She meets the requirements under the FMLA and the PDA. She possibly could win the lawsuit under the ADA also. It's not worth the risk associated with terminating her for moral reasons. I do understand your position, ma'am. And should you need further legal advice, please contact me and I will be willing to go to talk to you and go through the steps that need to be taken to further your case. Thank you for your time, Ms. Jones. And again, if you have any other legal questions or you would like to retain legal counsel, please call me back. Thank you.